This is Barry Zalma speaking for Claim School Incorporated's newsletter, Zalma's Insurance Fraud Letter for October 15, 2024. This Volume 28, Number 20 of Zalma's Insurance Fraud Letter is distributed free to anyone who subscribes and to all clients of my consulting firm, Barry Zalma, Inc. You can subscribe at the link provided, and you will receive the 21-page October 15, 2024 issue as the source for the insurance fraud professional. Zalma's Insurance Fraud Letter continues its 28th year of publication dedicated to those involved in reducing the effect of insurance fraud. ZIFL is published 24 times a year by Claim School and written by me. It is provided free to anyone who visits the site at Zalma's Insurance Fraud Letter, and the issue contains the following articles about insurance fraud. First, intentionally presenting a false claim is and always will be in almost every one of the 50 states a crime. Insurance fraud exists at the time the false claim is made, not payment of the false claim, and there's no need for an insurer to pay a false claim for a person to be convicted of insurance fraud. For example, a Knox County, Tennessee jury convicted John M. Fletcher of initiating a false report to a law enforcement officer and presenting a false or fraudulent insurance claim. The trial court imposed an effective sentence of 4 years on Mr. Fletcher. In a case entitled State of Tennessee versus John M. Fletcher, the Court of Criminal Appeals of Tennessee on September 24, 2024, disposed of the false report to a law enforcement officer and dealt with the insurance fraud scheme. You can read the entire article and the full issue of ZIFL at the link provided in the blog. Then there is more on McClenny, Moseley Associates. This is the 36th installment of the saga of McClenny, Moseley Associates and its problems with the federal courts in the state of Louisiana and Texas, and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct, to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. Equal Access Justice Fund, the EAJF, a few months ago asked the bankruptcy court to appoint a Chapter 11 trustee for MMA's estate. The funds accuse MMA fraudster Zach Moseley of fraud, dishonesty, incompetence, and gross mismanagement. You can read the full article and the full issue of ZIFL at the link provided in the blog. Then there's an article about how gangs are now involved in fraud and murder, proving that insurance fraud is a violent crime. Gang defendants present multiple motions in the United States District Court in Wisconsin to avoid or delay trial for COVID-19 fraud and murder for hire. In a case entitled The United States of America versus Ronell Bowman and Ronnie Jackson, the United States District Court for the Eastern District of Wisconsin on October 7, 2024, dealt with the defendants who were charged with conspiracy to commit murder for hire and using a firearm during the commission of that defense, with participating in a conspiracy to possess, sell, or transfer firearms in various illegal ways, and charged with both substantive mail fraud and mail fraud conspiracies. You can read the full article at ZIFL at the link provided in the blog. Next article is Chutzpah. Fraud perpetrator tries to use the court to avoid paying a judgment. A fraud judgment for $45,657,401.01 against a fraudster seeks bankruptcy protection, and the court refused to allow procedural rules to enable a fraud perpetrator, Mr. Looplover, to manipulate the federal court to avoid paying the judgment. Before the United States District Court for the Eastern District of New York was the motion of non-debtor respondents Michael Looplover and NJTM Ventures, LLC, seeking reconsideration of the court's July 29, 2024 order establishing a temporary restraining order so that they couldn't throw away and spend all of the money needed to pay the judgment. The entire article and the full issue of ZIFL is available at the link provided. Next, there's a listing of health insurance fraud convictions, usually from the United States District Courts and the U.S. Department of Justice, starting with the article about Magellan Diagnostics was sentenced for concealing malfunction in lead detecting devices, where Magellan, a medical device company headquartered in Billerica, Massachusetts, was sentenced October 9, 2024 in federal court in Boston for criminal charges related to the concealment of a device malfunction that produced inaccurately low lead test results for tens of thousands of children and other participants. You can read the full article with additional reports of dozens of convictions in the full issue of ZIFL in Adobe PDF format at the link provided. Then there's a listing of convictions other than health insurance fraud, starting with a Southern California residents who were providing legal representation to people in California without a license and were arrested by a task force. Defendants had filed claims for clients, including property damage claims, after the Saddle Ridge wildfire in Los Angeles. Pedram Cherokee, 41 of Porter Ranch, also known as Peter Shaw and Peter Cherokee, was practicing law associated with personal injury claims without a proper license. Cherokee also filed several property damage, smoke, and ash claims on behalf of the claimants after the wildfire. You can read about this article and other convictions for not other than health insurance fraud at the link provided, as well as the full issue of ZIFL. And then there's an article about the effect of the tort of bad faith, because it seemed to the California courts that it was indisputable that in the 1950s, 1960s, and 1970s, that the insurance industry abused some insurers to avoid paying legitimate claims, and without a factual basis, insurers were accused of arson or other variations on insurance fraud. Indemnity payments were refused on the flimsiest of excuses, and people were found to have diseases that only horses could catch. Disability payments were refused because an insured was wheeled in her wheelchair to church one day and therefore was not totally house confined. Insureds were driven into bankruptcy when reasonable demands within the policy limits were refused. The article goes on to conclude that the tort of bad faith has served its purpose, and it is time to find that it is now reversing the real reason for the creation of the tort. You can read the full article at my blog, Zalma on Insurance Claims, which is available free to anyone who clicks on the URL zalma.com/blog. You can also view these videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Thank you for your attention.